The Supreme Court of Canada consists of 9 judges, including the Chief Justice. They represent different regions of the country. The Supreme Court Act requires 3 judges must be appointed from Quebec, and by tradition, 3 from Ontario, 1 from the Atlantic provinces, and the remaining 2 from the West and North. Judges remain on the Supreme Court until they retire or turn 75, the mandatory retirement age.
The court, la cour.
To be a judge on the High Court, candidates must have previously been a judge on a court of appeal or superior court, or have been a lawyer of at least 10 years in Canada. In 2016, former Prime Minister Justin Trudeau created a new independent, nonpartisan advisory board to recommend qualified judges for consideration for the Supreme Court. Former Prime Minister and Justice Minister Kim Campbell chaired the advisory board for judicial appointments in 2016, 2017, and 2019.
Our committee vetted them according to a set of standard criteria that didn't involve political views at all. Certainly, functional bilingualism was one of them, and if candidates had some facility in both of our systems of law, common law and civil law, that was good. But we also met with the Chief Justice before each process to say, what in your view are qualities that are valuable for a justice on the Supreme Court of Canada. And one of the things that's really important is collegiality.
The Right Honourable Prime Minister.
In 2006, former Prime Minister Stephen Harper introduced a process for Supreme Court judicial nominees to appear before an ad hoc committee for questioning, a process similar to the one in the United States. A total of 5 court nominees appeared before committee, and the 5th, Marc Nadon, was the last in 2013 when the Supreme Court itself eventually ruled against his appointment based on criteria to sit on the court.
The public has to understand what we do, why we do it, and it's part of our job to explain it as we go along.
Though Nadon was sworn as a puisne judge for the Supreme Court, his appointment was contested and ended up before the Supreme Court as a reference case. In a 6-1 decision, the court ruled that Nadon's appointment was contrary to the Quebec-specific provisions in the Supreme Court Act. Nadon could not serve as a Supreme Court judge.
What the ordinary person would take.
Former Supreme Court of Canada Justice Michael Moldaver was on the court.
In the Nadon reference, in which I dissented, and I'm not going to get into the details of that, but what bothered me as much as anything is that this very decent man who had already been sworn into the Supreme Court found out within a day or so after being sworn in that he was not to come back to the court because there was a challenge to his appointment, and that such that he could not be qualified or eligible to be a member of the Supreme Court. And a big part of me felt so bad for this man.
The court can hear appeals from both provincial and federal court. It is up to the court to grant a leave of appeal. Frank Iacobucci served on the Supreme Court from 1991 to 2004.
When I was on the court, we were divided into 3 panels, so 3 on each panel. And there would be applications, sometimes 500, 550, 600. They would be divided among those 3 panels for should you grant leave, should you grant permission. There's just a standard that says of national interest, of public importance. Well, that, people can differ on that. So the panel would make a recommendation.
La préoccupation qu'exprime le juge en chef, c'est-à-dire
Justice Nicholas Kaserer began serving on the Supreme Court in September 2019. In February, he addressed a town hall in Victoria and spoke about appeals before the court.
we had just over 500 applications for leave to appeal, and 88 came from British Columbia, 64 from Alberta, 160 from Ontario. So the balance 5 from Newfoundland. The balance is kind of across the country. No country monopolizes our attention, nor do we have any trouble finding things to do from all corners of the country.
Respect for Canada's democratic traditions and institutions.
Beverly McLaughlin served on the bench for 28 years, from April 1989 to December 2017, the last 17 of which she was Chief Justice.
A hearing date is set, the case is heard, and the judges then take it under deliberation. They all retire to a meeting room, which is behind the court, and it's private, and they discuss the case. When my day, we would start with the most junior judge, which had been the tradition before me, and it was a great tradition, I thought, because it kind of forced the more junior person into the discussion.
Finally, the third way a case can come before the court is by way of reference from a provincial or federal government. The court's answer to a reference question is not legally binding. Typically, the government referring the matter follows the court's advisory opinion.
It is a power one should use sparingly, because in most cases that go before the Supreme Court of Canada, the court has the benefit of the record of the lower court deliberations and decisions. So when you send a reference to the Supreme Court of Canada, you're asking them to sort of ab initio render an opinion on a subject where they don't have the benefit of those different levels of court decisions. I sent a reference to the Supreme Court of Canada when I was dealing with David Milgaard's case. And the reason I did that was because David Milgaard's case was very controversial. I sent a reference to the Supreme Court of Canada asking them to review all the material that I had and to give me an opinion whether, in their view, there had or was likely a miscarriage of justice. So they recommended that I quash his conviction, and I did.
I think the reference that stood out in the time I was on the court, and it still is incredibly important, was the reference on the province of Quebec's right to secede from Canada. The secession case, it's called. And that was dealing with the existence of our country in terms of the nation, statehood, and what does the Constitution's response?
Author and law professor Adam Dodek.
These are some of the most sensitive, most political issues. And the court is not supposed to be a political organ. Their job is not to come up with the best political answer. Their job is to come up with a legal answer. But these questions are inevitably political. So that's one of the first challenges or dangers. The other is that this is an abstract question, right? These are literally just a question asked. Is this constitutional? Is the appointment of Justice Nadon consistent with the Supreme Court Act, or does it require a constitutional amendment? There's no evidence in these cases.
Good morning, please be seated.
Each justice on the Supreme Court is supported by law clerks. Jean-Simon Schoenholtz and Anna Maria Enninger worked as law clerks at the Supreme Court.
As a law clerk, our functions are to assist the court in making its decision and assist our particular judges. To also, challenge them to a certain degree in their decision making and raise counter arguments and have discussions with them.
Various judges have different approaches. My judge wanted a bench memo, which is a type of document that's produced by the law clerks that looks at the history of the case, the position of the parties, any unique aspects that are introduced by interveners, and sort of does an analysis of what the core issues are, what the dispute is in the case. Before the hearing, some judges also have their law clerks prepare questions.
The present court opened in 1946. The main courtroom in the Supreme Court is located in the center of the building on the first floor. Judges sit in order of seniority, to the right and left of the Chief Justice or presiding judge. Robert Schertzer studies the High Court and teaches political science at the University of Toronto.
Chief Justices play an important role in the chief administrator of the court, right? They try and herd the cats of the other justices, right? Try and make sure that they're going to make decisions as a body, as a group. And various chief justices have had different perspectives on how the court should function. Earlier in the court's existence, it tended to be that you would have decisions authored by majorities and dissents, minorities, and individual justices, even if they were in the majority voting for an issue, would author their own decision, right? So you'd have 9 decisions sometimes being authored of different perspectives on the law.
Decisions of the court do not need to be unanimous, but the minority will write their reasons for a dissenting opinion. All judgments are published simultaneously in both official languages.
The court needs as much as possible consensus because the consensus gives clarity. The rest of the country is taking its lead from the decisions of the court.
Legal historian and professor Constance Backhouse says the demands of the court, including caseload, can take its toll on those on the bench.
Probably the best line that I ever heard about this was our wonderful Rosalie Abella, now retired judge from the Supreme Court of Canada, who said, you know, there are 9 judges on the Supreme Court of Canada. It's like having 8 spouses, none of whom you picked. And I thought, well, that is a pretty interesting summing up of how tense it can get.
For 150 years, judges have worked together to come up with legal answers based on the Constitution and the Charter. The clarity the court provides in its decisions give Canadians a better understanding of their rights. It also gives the legal system guidance on possible future cases that may come before the High Court. Coming up in our next episodes, we bring you more on the critical importance of judicial independence.
Courts have to be impartial. And for that reason, they have to be completely independent of these other branches of government and seen to be independent.
The role of the court.
It has a role that's somewhat like a parent. That, you know, when parties are disagreeing or have a significant conflict, someone has to render a decision. And so that's largely what our Supreme Court does in our system of government.
And we look back at its history. All that on the next installments of CPAC's Inside the Supreme Court of Canada, 150 years of the highest court in the land.